If you or a loved one receives Medi-Cal, you've probably heard about the state trying to take back some money after someone dies. It's true. California can seek reimbursement for certain benefits through a process called estate recovery. But not everything is subject to payback. In this video, I'll break down exactly when and how Medi-Cal can recover money, what kind of assets are at risk, and what steps you can take now to protect your family. So Medicaid, which is the federal program, has what's called an estate recovery program. And this requires states to seek reimbursements for certain benefits. In California, there are really two times our state is allowed to seek a reimbursement claim. That is, Medi-Cal can get their money back after a Medi-Cal recipient dies. But Medi-Cal isn't allowed to go after any and all money that the Medi-Cal recipient might have when they die. In fact, they can only pursue claims in these two situations, and they're both described in 42 U.S. Code Section 1496P. That's the code that talks about Medicaid recoveries, if you care about that sort of thing. So the first situation where Medicaid can bring an estate recovery is when a deceased Medicaid recipient has an ownership interest in an asset. So this is spelled out in subsection 2. It says, the state shall seek adjustment or recovery of any medical assistance correctly paid on behalf of an individual under the state plan in the case of the following individuals. A, they seek recovery from the individual's estate, and B, they have to be 55 years or older when they received that medical assistance. So that sounds pretty serious, right? I mean, recovery from your estate for all medical assistance? Well, California has limited that. In 2017, California passed a law called SB 833. This law limited the types of assets that Medi-Cal can bring a recovery claim on. Now those assets need to be part of a deceased person's estate, like it says in the code, but what really constitutes that estate? Well, California says if an asset is subject to probate, that's when you know it's in an estate and Medi-Cal can bring a recovery claim. So if there's any way of getting an asset to the next generation or somebody else without going through probate, it's not subject to recovery. So for example, if an asset is held in a revocable trust, it's not going to go through probate when the settlor dies, and thus it's not subject to a Medi-Cal recovery. Or if an asset is titled in joint tenancy and it automatically goes to the other joint owner when the first person dies, no Medi-Cal recovery. Or if it's like a retirement account and it has a designated beneficiary named and it goes straight to that beneficiary, no recovery. Also, if the total assets in the estate are less than about $200,000, then you can use a small estate affidavit to get that money directly to somebody else. No probate, no recovery claim. So really, it's only the assets going through probate that Medi-Cal can bring a claim against, which is pretty awesome. So how big will this Medi-Cal claim be? Well, Medi-Cal starts counting all the assistance that somebody's gotten starting at age 55. This can be in a nursing home, or it can be if somebody's living in the community. So here's an example. Let's say that Medi-Cal has paid $300,000 of health assistance for somebody before they turn 55, and then $200,000 after they're 55, and then that person dies. How big will that recovery claim be? It would only be $200,000. It's only the money starting at age 55 that the person received in medical assistance. Now, the other type of Medicaid recovery that's possible is against a first-party special needs trust when the disabled beneficiary dies. This is also called a self-settled trust. This is a special needs trust that holds the beneficiary's own money. Now, this is spelled out in our favorite section, 42 U.S.C. 1396P, but then it's D4A. So take a look. And that's, by the way, that's why first-party special needs trusts are also sometimes called D4A trusts. So it talks a lot about different things in D, and then it's saying that this subsection, which prevents recovery, shall not apply to a trust containing assets of an individual under age 65, right? So this is where we get the rule that a first-party special needs trust can only be funded with the beneficiary's money up till age 65, who is disabled, and which is established for the benefit of such individual by certain people if the state will receive all amounts remaining in the trust upon the death of such individual up to an amount equal to the total medical assistance paid on behalf of the individual under a state plan. So basically, everything that Medi-Cal has paid for on the beneficiary's death, Medi-Cal gets to bring a recovery.
Did you know my mom has a monthly newsletter where she shares helpful information? Click below to join.
Note that there's no limitation for age 55 and up. So that means anything that Medi-Cal has paid for the beneficiary starting at birth, going up to when the beneficiary dies. And there's no limitation for you can only recover against things, once the first party special needs trust was set up. All right, so they can bring a recovery, they calculate the recovery claim on everything that Medi-Cal has paid for over the beneficiary's lifetime. Now, please note that this doesn't apply to third party special needs trusts, which are the more common ones out there. That's when somebody else sets up a special needs trust for the benefit of a disabled person. And that's someone else, like a parent, a grandparent, a friend, a family member, an auntie, then funds that trust. So the beneficiary does not put their money into the third-party special needs trust. There's no Medi-Cal recovery for third-party special needs trusts at all. So let's look at that last example. There is a disabled person who received $300,000 worth of medical assistance by Medi-Cal up until age 55, and then $200,000 more after age 55 until they died. From a first-party special needs trust, how much could Medi-Cal bring a claim against? $500,000. The entire lifetime of that beneficiary. I know it's different than the recovery against the amount that might pass in probate. Yeah, this doesn't seem fair, but it's the law. Now, you may have heard of IHSS in California, In-Home Support Services. IHSS is home-based, and it helps pay for caregivers who are providing help for activities of daily living to people who have developmental disabilities, or they might need some elder care. IHSS is delivered under the Medi-Cal umbrella, so Medi-Cal can bring a recovery claim against any money or services paid for by IHSS. But what about other public benefits programs? Can they bring a reimbursement claim? None of them. So this means that there's no recovery claim against a beneficiary's money or a first-party special needs trust if that beneficiary was receiving SSI, SSDI, CalFresh, otherwise known as SNAP or food stamps, Medicare, or Section 8 housing. I mean, you might expect SSI to bring a reimbursement claim since they're so strict while you're alive, and stingy too, but they don't have an estate recovery program. However, if SSA, Social Security Administration, determines that they've overpaid what the beneficiary received under SSI or SSDI, they can claim a recovery for that overpayment. So it's kind of like, oh, they paid too much, they get that overage back. But it's different than a Medi-Cal recovery claim. Okay, so how might this affect you? Well, if you're receiving Medi-Cal, you'll definitely want to set up your assets to avoid a Medi-Cal recovery claim on your death. This means you should set up a revocable living trust to hold all of the assets that you might have in your own name. Now, why would you have assets in your own name? Well, there's some assets under Medi-Cal that are exempt, right? That could be your house, a car, burial plot, a retirement account that's not paying out. There's different things that you can still hold. But on your death, if your house is titled just in your name, then guess what? That house would go through probate and it's subject to a Medi-Cal recovery claim. I don't think anybody wants that, right? And you're having to deal with the probate court and all the probate fees and everything. It's like a double whammy. Not ideal. So in that case, you should put your house into a revocable living trust. Then when you die, your house doesn't go through probate and there's no Medi-Cal recovery claim. Also, if you want to leave money to somebody who's currently receiving Medi-Cal, you should leave it to their third-party special needs trust instead, since those types of trusts are not subject to Medi-Cal recovery claims. Don't leave the inheritance directly to the disabled individual, since they'll need to turn around and put that money into a first-party special needs trust in order to keep their Medi-Cal benefits. And then when they die, all of that money in the first-party special needs trust is exposed to a Medi-Cal recovery claim. And that could completely deplete the trust. So Estate recovery can really catch families off guard, especially when somebody's home or trust is involved. If you or a loved one is receiving Medi-Cal, it's so important to plan ahead. Setting up a revocable living trust, understanding the difference between first-party and third-party special needs trusts, and properly titling your assets can make all the difference. If you'd like help putting all these protections in place, please contact our office. We specialize in helping Californian families with estate planning and special needs planning.
If this video is helpful for you, share it to someone else who might benefit from it.